So at the arraignment, the defense here apparently was already sort of laying the seeds or planting the seeds of a change of venue type of argument, saying it's not going to be possible to give my client a fair trial here in this jurisdiction. I think that will fall on deaf ears, but we shall see. Mm-hmm. And then, once he's out of that frying pan, he's back into the federal fryer, so that he's not going to get anywhere with that. But yeah, so at the arraignment, you can either enter a plea of guilty, not guilty. Sometimes you ask for a continuance to have your client evaluated for things like insanity. Mm-hmm. So you request additional time. If you don't think your client's competent and there might be some issues there, you ask for an evaluation. But yeah, generally speaking, arraignment's just procedure.
Okay.
And on the indictment, again, there'll probably be another discussion about bond and whether your client should be in or out. And then once you plead not guilty, the case goes. Discovery occurs. You file demands for discovery. The government has to give you information. The court conducts pretrial hearings if you're challenging evidence through motions or otherwise. And then ultimately the case goes to trial. So that's what Mangione has in store for himself, not only now in state court, but also federal court. So it can happen, and it is happening. Mm-hmm. And I think we should track it. We should keep watching it.
Yep. So next update is just see what the federal side does, and then now state side discovery. It's going to be It'll
be interesting to see if the feds get it together soon enough to avoid a prelim. But I'd love to see the preliminary hearing. Mm-hmm. So anyway, this is Lawyer Talk.